Hello, everybody. It's attorney Laura Sterling, and welcome to my what month are we in? February. My February live. Can you believe it? Friday is already March. I'm actually looking forward to March because I don't know if you know this about me, but I'm a big Disney person. I love going to Disney. And March starts out their flower and garden show, which I really love. I like looking at the flowers, and they have these topiaries, I think, and they shape them in Miss Piggy and Kermit and the crocodile and Peter Pan. It's just really nice. So I look forward to March, and it starts to get spring like here, and it's not so humid, but the weather is beautiful. So I'm actually looking forward to March. But we're still in February, and February we have that little boop extra day because it's a leap year. So we get that extra day in February to get whatever we need done in February done before March hits. So, but welcome, welcome, welcome to my live show. As you're aware, you know that this month we've been focusing on probate, and everybody always goes, probate. They hate it, but it's really not that bad of a thing. I mean, it can be a very simple process, it can be fairly quick. It just depends. So, that's what we're going to talk about during this live show. So, I hope that you're tuning in, you have your questions written down from watching my videos all month. The one I had when I was in Minnesota, can you believe it? There was like I almost like fell out of my chair. There was no snow on the ground. Now, my parents, as you're aware, as I've told you many times, I talk about them all the time. They're in northern Minnesota, so there was snow. I mean, not a lot of it, but there were patches of snow. But once you head out and start heading down south, like towards Minneapolis, nothing, nothing, no snow. I mean, that is so strange for Minnesota. And you saw when I did my video outside, I didn't have a jacket. I didn't have a hat. I didn't have gloves. I had nothing. I was standing out there in my little sweater, my jeans, and I don't even think I had shoes on. Isn't that scary? But yeah, I was having a nice time, with the no snow. Now it did get cold when I was there to where I was bundling up, but we just had some powdering, as we like to call it in Minnesota, of snow while I was there. Of course, I got dumped on after I left, which is fine with me. You can dump all day long when I'm not there. But anyway, so you saw the one video that I did in Minnesota and then came back here and, of course, did my regular videos. So, as I'm saying, we're talking about probate this month. So, why don't you relax, sit down, lay down, whatever you do to watch my live shows. Have your little pen, have your little piece of paper, or have your electronic device or your laptop or whatever so you can take notes, or you can just drop something in the line with one of your questions, drop it into the chat. I'll be more than happy to, entertain it for you, answer it if I can. Please remember when you ask a question, I am talking from Florida law. Remember, I'm a Florida licensed attorney, so I can only address questions for the state of Florida. So when I answer if you have a specific question, I'm going to answer it in a general term. I'm going to answer it how it is here in Florida, and I'm going to direct you to see an attorney in the state that you live, just so you have the correct information. Not every state is the same. Every state is different. Every state can set their own laws. So don't think, well, one state's just like the other, because it's not. Okay. So just know that where I'm coming from is Florida, the sunny state. Finally, the sun. We had rain for so long this year. But anyway, so sit back, relax, do whatever you do to take notes. Have your little water. I have my little water here. Of course, I'm going to be the one talking. Have your little snack if you wanted to, depending on what time it is. You could be having a snack. It's 2:00 here, 1:00 in Minnesota, 11 o'clock in California, whatever. Make sure you're comfy. We're going to be here a while. So, again, welcome. As you know, I'm attorney Laura Sterling. I'm here once a month doing a live show. I do my videos throughout. I give you a little glimpse of my life, what I've done all month, and what I do for fun a little bit in there, just to give you a variety, because you don't want to see, me doing videos all the time. That can be kind of monotonous. I like to break it up a little. We're talking about probate. So everybody gets so scared with probate. Everybody thinks that when a probate is open, that somehow the state is going to swoop in and take everything. I don't know who in the state will come. State of Florida is just going to come and take all your stuff. That's not the case. sometimes a probate is necessary. And I'm going to talk about ways that you can avoid probate as well. And that'll help, especially if you have a small estate and you can do certain things to make sure that you don't even need to step foot in court. You don't have to file anything. You don't have to go through anything like that. So I'll help you with that as well. But a probate comes into play with, well, I want to say with your things and stuff. I'm going to say things and stuff a million times during this hour, but that's really what probate is, your things and stuff. Probate has nothing to do with your body, nothing whatsoever. I think we talked about that last month with living wills, power of attorney, healthcare. That's that. That deals with this. Wills and probate deal with things and stuff. My car, my house, my 401k, my furniture, my jewelry, my mementos or whatever, my collection of stuffed dolls. Stuff is the mascot for the Orlando Magic, Go Magic. But that's what probate deals with. It deals with your things and stuff. If you haven't already dealt with your things and stuff, that's what probate is for. So, probate has kind of, let me start with, probate is, you've drafted a will. So we have testate and intestate. That's what we have in the state of Florida. So testate, testate, testate means I've given a testimony. I have done a last will and testament. So I'm dying testate, meaning I have a will. I have said where my things and stuff are going to go. Where do I want my house to go? Where do I want my bank accounts to go? Where do I want, who do I want to get it? Who do I want to be my personal representative? When somebody passes away, testate, that means they have a will. That's the term we use here in Florida. Intestate, that's what we use in Florida, is when somebody dies without a will. Things and stuff. Their things and stuff are out there in limbo because they never said in writing, by the laws of the state of Florida and by the laws in your state, what I want done with my things and stuff. So everything is out there. And now, oh my goodness, what do? We have to transfer the deed of the house to the beneficiaries. What about the car? How do we get that changed over? What about bank accounts? What about anything like that? Now, to avoid kind of that testate, intestate debacle, you can always put beneficiaries on stuff. You have bank accounts, you can go to your bank, do a transfer on death, payable on death, in trust for. That way, you pass away, your bank accounts just automatically go to these beneficiaries. Now, understand the beneficiary has absolutely no claim to it while you're alive. They're simply a beneficiary. Like on a life insurance policy, you have the life insurance policy, you have beneficiaries. I can't collect on my mother's life insurance policy while she's alive. That doesn't make any sense. It's only when she passes am I able to collect. So the same thing with these bank accounts. You have a checking, you have a savings, you can put beneficiaries. That way you don't have to worry about doing a will because it's all going to pass in a beneficiary. It won't go through probate. It'll go directly to your heirs. Now with a house, you could potentially do a life estate deed or a ladybird deed, and that could transfer. In Minnesota, I remember years ago, we did a beneficiary deed that whoever owns the home, my parents, if they pass away, it comes to us as beneficiaries. So there's things that you can do. So you always need to check that out when you sit down to draft a will with your attorney. When you sit down and do that estate planning with your attorney, and please, please, please do that. Sit down with your attorney and go over everything, because what happens is this. We go, oh, I'm going to do that later. Oh, I'm busy. Oh, I got something to get. Oh, this is more important. That's more important. But we never know when something's going to happen. And if you die intestate, now your things and stuff, you don't have a will, they're kind of out there. And let me give you an example. I'm going to give you an example of both, okay? Of some famous people that died testate with a will, intestate without a will. Let's go to my wonderful home state of Minnesota. Who died that recently that's very famous that's from Minnesota? Yes, quit yelling it. It's Prince. You're exactly right. Prince was a young guy, right? He was in his 50s, passes away suddenly, did nothing about his things and stuff. He died intestate. He did not have a will. He did not direct how his things and stuff were going to be devised. And Prince had a lot of things and stuff. He had a lot. He had property. He had that vault with all those unreleased music and all that unreleased videos and all of that. It took, they had to open a probate. They had to open a probate because they had to figure out who got his things and stuff. And do you know who filed? How many people, if you listen to my podcast, you know how many people filed claims saying they were some relative or some distant relative of Prince? 700 people. I was not one of them. 700 people filed. They ended up with six. One was his full sibling, meaning they shared parent. They shared mom and dad. The other were half. I think they were from his dad or from his mom or something. So there were six out of 700. They were able to shimmy out six. Isn't that awful? And they actually had to take DNA from the autopsy of Prince to be able to connect these people to him, which is a sad state of affairs. Just let the man rest in peace. But because they had so many people, they needed to figure it out. And it took quite a few years to finally get his estate settled. And so see what that does is it just keeps it going in the court. And guess who makes a lot of money off of it? Attorneys, because we're the ones keeping it alive and we've got to figure it out and we've got to fight. And maybe there's a fight and maybe there's this and maybe there's that. And in the end, well, Prince will continue to make money even after his death. But if it's just, regular old me, the money's going to run out at some point, right? And who's got most of the money? The attorneys. So that's why it's always good to have a will to make sure your things and stuff are taken care of and you die testate, not intestate. Now, I did what not to do with Prince. God rest his soul. Who did a will? Who made sure things were taken care of when they pass away? If you listen to my podcast, you know the answer. Elvis Presley. When Elvis Presley died, he had a trust, and it was very, very specific about who the heirs were, what they got, all of that. In the end, the only living heir on there after all was said and done was Lisa Marie. And at 25 years of age, she got it lock, stock, and barrel. She got everything associated with Elvis Presley. And thank God for her mother, Priscilla, because she made that estate worth what it is today. She really built it up. So Lisa Marie she got all of that at the age of 25. When Lisa Marie passed away, she had a trust. So she took care of it. She took an example from her father to make sure that her things and stuff were taken care of. God bless her. Because when she passed away suddenly, it was able to go to her children. She had that one adult daughter and the two twins that are younger, that are underage. First, if you listen to my podcast, there was a little with Priscilla, but Priscilla was taken care of and she's dropped out. And now Riley, who's her oldest daughter, is able to be the trustee for the two younger children until they reach the age of majority. So Lisa Marie made sure she had it together so her things and stuff would be taken care of upon her death. So it was a little easier process. Not to say that people won't come in and try to, because I'm telling you right now, people will fight over a dollar, whether it's $1 or $1,000,000, they're going to fight for it. So it doesn't mean you're free from fighting, but at least it's written, your wishes are down, and the court can go off what your wishes are. So, hey, Christopher, how are you? Oh, it's nice to see you too. I'm so glad you tuned in. I hope you're enjoying my war stories from the stars, right? Anyway, so that's how we deal with testate, intestate. Now, when somebody dies intestate in the state of Florida, please, again, make sure that you're checking with your own state. When you die without a will and your things and stuff are in limbo, it really depends on who your heirs are as to who stuff goes to by law. So, God forbid, let's say I die tomorrow. Yeah, God forbid. My spouse will get everything because he's my spouse. Now, we do have a child. We have an adult child, right? Well, he acts like an adult a majority of the time. The other part of the time, you know. But anyway, we have an adult child. But that adult child is the child of both me and my husband. So, because he's the child of both me and my husband gets everything because he's the child, because he will stand to inherit from my husband, right? From his father. So he'll stand to inherit from my husband. So that's why everything automatically goes to my husband if I don't have a will. If I don't have a will and I'm married to my husband, but my husband has a child from another relationship, another marriage, another one, whatever. He has a child that's not mine, not mine. Or I take that back. He has, yeah. So he would stand to he could get half of it. Well, he would get the whole part and the child would inherit from him, even though that child is not my child. Now, if my husband dies first and he has a child that is not mine, he has a child from somebody else, I'm only entitled to half because he has a before born child before our relationship. So the other half would go to his child that is not mine, unless that child says, I don't want it. I don't want it. Here's stepmom, you can have it. You can have it. You can have everything. I don't want it. And I have that happen a lot in intestate estates where the spouse, my husband dies first, he's got children from another relationship, there's a home. Now, in the state of Florida, when there's not a will, that home or that home is not owned jointly with me, then I only get a life estate as a surviving spouse. His children from another relationship get the remainderment, meaning I die, it automatically goes to them. But if they don't want it, they can sign off saying, we want nothing to do with that home. She can have it lock, stock, and barrel. And I've actually had that happen. And I've had it happen in the reverse too, where the surviving spouse, me, where I'm getting the life estate and the children are remaindermen, where I'm signing away my rights to it and I'm giving it to the children, saying, listen, I don't deserve it. You guys should have it. I was only married to your dad 5 years, So here you go. You get the house. I don't want the life estate. And for those of you who don't know what a life estate is I can live in it for the remainder of my life. I can do what I want with it. But when I die, it goes to his children. It goes to the remaindermen. So they can't kick me out. They can't say, okay, mom or stepmom or mom, or whatever, you're out. You don't know how to take care of this house. No, that I can live in it for the rest of my life. When I pass, then it goes to the children. So I can always give that up. I can say, I don't want it. I don't need it. It's too much of a hassle. You guys just take it. So there's a lot of nuances with the law. So you really have to make sure that you check with the state that you're in, especially because we have so many second marriages and children. You have her children, his children, the blend, the together children. It can be very confusing as to who gets what and where and why and how. And that's why it's best to sit down with an estate planning attorney and get this taken care of, get your things and stuff taken care of, because my goodness, you die. And then now there's all these people that are fighting and fighting and fighting. I don't know if you see the commercial about Chewy or something like that, and they're reading the will, and there's the cat there, Mr. Chewy. Mr. Chewy's getting the entire estate, and one of the kids only gets a train set, and they're like, wait a minute, Mr. Chewy's a cat. And Mr. Chewy's like, yeah, I got it made. He got the summer house. So it's very cute. But anyway, so that's intestate and testate. So make sure you check out those laws and the succession, the order of succession in your estate if you die without a will. But hopefully you don't need to know that because you're going to do a will. And so therefore, when you die, it'll be in testate and you can make sure that everything is taken care of. Hi, Martin. My brother passed away. I'm so sorry. I'm sorry to hear that. And his only income was Social Security income. He has 4,000 in the bank and owns two vehicles. Will my nephew need a probate lawyer to manage this? Again, Martin, lovely question. Fabulous question. In the state of Florida, I mean, 4,000 in a bank. I'm assuming his bank account only had his name. It didn't have a beneficiary. The best thing would have had him put a beneficiary on that. So your nephew would only have to go to the bank, show ID, show proof of death. Boop, there you go. The 4,000 is yours. If there's not a beneficiary or he didn't own it jointly with anybody, if he owned it jointly with a girlfriend or whomever or wife or whatever, it would automatically go to that person. But if he didn't, it was solely in his name, then yeah, the bank's not going to give it to him. I'm going to tell you right now, the bank will not give it to him. Or the bank will write the check to the estate of your brother. Let's say your brother's name is Harold. So Harold O'Reilly. The estate of Harold O'Reilly, and they'll hand your nephew a check, and your nephew will look at the check and be like, he won't be able to cash it. He's going to have to open a probate. Now, here in the state of Florida, two vehicles can be considered what we call exempt property, meaning creditors cannot go after two vehicles. And they say over a certain weight, but please, come on, cars are cars. I'm sure it's not an 18-wheeler. If it's an 18-wheeler, it's not exempt property, but a car and SUV, that is exempt property. So two vehicles, he would need to file a probate, though, to get those two vehicles transferred over and to get them determined exempt property so that creditors don't come after those vehicles. Now, I do want to tell you, if there's loans on those two vehicles, now, of course, those loans have a right to those vehicles. But let's say he had an American Express with $10,000 on it. American Express can't come and capture those vehicles. So it would only have to be the loans that are on those vehicles. And once they get determined exempt, and let's say he's able to transfer, your nephew's able to transfer them into his name, you still got the issue of the loans on them. So nephew would have to somehow satisfy those loans, whether it's him getting his own loan to take over, to pay off that loan. And now he's got a lien on those cars, or he just pays it off and gets it free and clear, because I don't think they really care. But the title, well, then here in Florida, you don't get the title to the vehicle until the lien is satisfied. So if you have a loan on one of the vehicles through Chase Bank, you don't get a copy of the title until you pay off Chase Bank. So in different states, it's different. So, but that's how it is in Florida. So the unfortunate thing is, Martin, like I said, if he didn't have a beneficiary on the bank account and those two vehicles need to be determined to be exempt, he probably will need an attorney to file a case. Now, you didn't say how long ago he passed away, but a fabulous question. So let me kind of expound on that. There are creditor claims. We call them creditor claims. And so those creditor claims here in Florida have 2 years from the date of death to file a creditor claim. If there's been nothing opened in the court, they file this claim. If the person has been deceased for more than 2 years, they're barred. They can't file. They can't, let's say you don't file a probate for 4 years. You file it in 4 years from now, 2028. A creditor can't come in and go, oh, hey, here we are, I'm filing a claim. They can't do that. Now, if they filed it during that 2-year period, the creditor claim can do that. Amex, American Express, can go, I heard that he died. I'm filing this creditor's claim in the event that he files a probate, whether it be now within the 2 years or 4 years down the road, because they're locking in their time. And that creditor claim will just sit there and it may never be satisfied because maybe there's never a probate filed. Or if a probate is filed, then it becomes active because it filed it within that time period. But a creditor claim can come after. And let's say he opens a probate, $4,000 in cars. Okay, you have to pay an attorney. You got to pay filing fees. You got to pay certain fees associated with the probate. You may exhaust that $4,000. He's going to get that $4,000, but then he's going to end up just paying himself back. He's going to kind of cut even. But the vehicles are the concern where, okay, these two vehicles that I can't touch right now, but need to get those determined as exempt so that creditors can't come after it, and he can change the title in his name. But very good question, Martin. And again, I'm sorry about your brother. I hope that everything is going well for you. Anyway, okay, so we kind of jumped ahead to creditor's claim, but first I want to talk about the different types of probate here in the state of Florida. We have a summary administration and a formal administration. A summary administration is for somebody, like I said, who has been deceased for more than 2 years. Now, of course, it can always be before the 2 years, but I only use a summary administration when I don't have to claw for creditors, when I don't have to hunt and peck and search and do whatever I need to do to find out about creditors. Summary administration is best when it's beyond that 2 years. Now, I recently had a case. Hold on one second. Hold that thought. I had a case where mom had been deceased for 4 years. So in the state of Florida, creditors are barred, right? Unless a creditor filed within the first 2 years. 4 years, they're barred. If they come now on the 3rd year or the 4th year, you're out. I just got a creditor claim set aside because the case has been open, and they had their 90 days because I sent out the creditor's claim and they tried to file a claim. I got it set aside. But anyway, the summary administration is for somebody who's been deceased more than 2 years. So mama's deceased for 4 years. They never opened a probate. Never, ever, ever. And there's a home. And so the home was never transferred to anyone. It's still in mom's name 4 years later. You need to get it out of mom's name, because what if a hurricane comes and something happens to that house? Guess what? It's still in mom's name. So the insurance is going to pay out in mom's name. And mom's not alive. I've had that exact thing happen to clients. Oh, I have this check on my sister's house and it's made out to her, but she died. Well, did you ever transfer the house? No. Well, there you go. Now I got to transfer the house so you can get the insurance money. So anyway, so they wanted to sell the house. But guess what? They can't sell the house because the house is not in their name. It was never transferred over. So they wanted me to transfer the house over so they could sell it, because they can't sell it. No title company is going to sell it. No realtor is going to sell it because it's not in their name. They don't have permission to sell it. They can't sign the contract. They can't do anything. But luckily, it was an easy process because I didn't need to look for creditors. I just had to do a petition to determine homestead. It got transferred over, easy peasy. Another thing with a summary administration is it's estates that are less than $75,000 in value, not including the home. Here in Florida, the home, as long as it's a homestead, you were living in it, it was owned by a natural person, all of that, it is protected. So it's able to pass from me to my heir. So if it's my child, my house can pass from me to my heir without a creditor attaching to it. American Express can't attach to it. Ford Motor can't attach to it. My medical bills can't attach to it. It has as much value as this pen. Here you go, son of Laura. There you go with the house. Now, when it transfers to my son, then it could, his creditors could, if he already has a homestead and all that. The mortgage transfers over. So now my son has to deal with the mortgage. Can he get a mortgage on this pen or this house? He needs to get a mortgage to satisfy the mortgage, get it out of my name, because now the house is in his name, and get a mortgage on the house, or just pay it off, whatever he wants to do. But that's a summary administration. They've been deceased for for more than 2 years, and and the value of the estate is $75,000 or less, not counting the home. The home has this much value in the estate. Oh, hi, Martin. There you are again. Thank you so much for your help and your kind words. Oh, you're sweet. That's very nice. Thank you, Martin. I appreciate that. A formal administration, that's a little more in depth, and that takes a little bit longer. Now, like Prince, it took years, but that was because 700 people believed they were the heir of Prince. But, it can take longer. It just is something that takes a little longer. And Prince had all those, that huge vault full of stuff that nobody knew about and they had to go through it. But usually they don't take that long. Hopefully they don't take that long. But a formal administration is for somebody who's been deceased less than the 2 years. And the creditors, we have to search for creditors. And I'll talk about that in a moment. And the formal administration is for estates that are more than 75,000, more than 75,000. Again, not counting the house, not counting the house. So if there's bank accounts out there with 100,000 or 200,000 and there's several pieces of property and all of that, that's what a formal administration is. A formal administration also appoints a personal representative. That personal representative makes sure that everything is taken care of and does an inventory and rallies all the assets, rallies all your things and stuff together and does an inventory and says, okay, this is what's in the estate. Who's entitled to it? Who's not entitled to it? Is there a will? Is there not a will? That's what they do. That's what their job is. And they can get paid to do that. Even a family member who is a personal representative can petition the court to get paid. They can. If it's a labor intensive estate, they can petition to get paid. So a formal administration appoints a personal representative. That personal representative is responsible to get that estate pushed through to get it closed. Because with a will, the estate has to close. It has to close out. It cannot be open for perpetuity. That's a trust. A trust can stay open and dictate terms. A will has to close. A will has to close. A probate has to close. Everything is parceled out and it closes. Your things and stuff have gone to the people that it should. That's what a probate is. Hi, Emma. Oh, I love your cat. What legal paperwork you need to prepare for probate court? Thank you. Oh, very good question, Emma. Well, in the state of Florida, depending on what you're filing, if you're filing a petition for formal administration, you got to do the petition for formal administration. You got to do an inventory. You got to do order for administration and order appointing a personal representative. The personal representative has to file an oath saying, I am the personal representative. I promise to, effectuate this estate, blah, blah, blah. And this is my agent in the event that anybody wants to serve anything on me as personal representative. Guess who it is? It's always the attorney. We are always the agent. So we get served with stuff. So that's kind of how you start the ball rolling. Then what happens is then we file a petition for homestead. Petition to determine homestead. Again, this is what we do in Florida. We're determining that the home, let's say there's just one piece of property, the home, that's where I lived before I passed away. So we need to tell the court, hey, this homestead should pass to Laura's son, Jim John, because it was a homestead to her. She lived in it before she passed away. She is a natural person. It fits the homestead criteria. So we need to file that with the court to get an order. If there's creditors, we need to file creditor satisfaction of creditors. So there's a whole bunch. But to first open it, we need a petition for formal administration and inventory. We need to get that order to appoint a personal representative. And then, Emma, if you can believe this, if there's next of kin, we need to get the next of kin's consent if that person is going to be personal representative. They need to sign a consent that they agree to have that person to be personal representative. If they don't sign a consent, then you may have to go in front of the judge so the judge can decide. But if there's a will, what do you think the judge is going to decide? The judge is going to decide whoever I put as my personal representative, unless there's some kind of incapacity or something like that. That's why when I do wills with people, I always have an alternate because you never know. You never know. You never know what could happen. But so there's an alternate there. But the court is going to look at your wishes. But again, if you don't have wishes, then the court's going to just pick whatever they feel is necessary based on what's being told to them. And you really don't want that. You want to direct from the grave who is going to take care of your things and stuff for you. So very good question, Emma. If you're here in Florida, I'd be more than happy to talk to you. Or if you're in a different state, please talk to an attorney in your state. So Anyway, and then there's some smaller kind of estates. There's an ancillary estate. That's, let's say the person died in New York and but they had property down here in Florida. You have to file the probate case where the person died. You can't say, well, yeah, she died in New York, but she has property down here, so let's open a probate down here. No, because Florida would be like this: bump, 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 take it back. New York, New York, you have jurisdiction over the body. So you need to open a probate in New York. And then down here, excuse me, down here in Florida, we would open an ancillary estate to take care of that piece of property here in Florida. So you would need a Florida attorney to take care of that property in Florida and how that is to be divided. Get a court order from Florida that will then be brought up to New York to show New York, okay, the property in Florida was taken care of. We're done. We're over. We can now close the estate. We actually had the opposite. We had a death here in Florida. There was property in Florida and property in New York. So the brother, we had the daughter. The son up in New York had to hire an attorney in New York, had to deal with that property in New York. Oh, Mama Mia, it took so long. It took so long. New York, I don't know. God bless you people who live in New York. I know it took long. I know things take long here in Florida too. Believe me, I am not trying to I'm not trying to kid myself. But oh, it took forever, forever. But we're finally closing the estate. Thank you so much. So, but that property in New York was taken care of. The attorney in New York sent us the paperwork showing it was closed. We were able to file that in our case down here. And now we can close the Florida estate and everything is fine and everything is dandy. Took a lot of, skinning our knees and bloody noses, but we got it taken care of. So that's just another form of an ancillary or a proceeding with, to get rid of personal stuff. There's just little things that can happen. Hi, William. Oh, what a nice picture. Good afternoon, Attorney Sterling. My question is, how is a will probated and examined by the court? Well, and like I was talking about, very good question. A will is probated, like I said, either the summary administration or the probate or the formal administration. Summary administration, if they've been deceased for longer than 2 years and their property is less than 75,000, minus, not counting the home, or the formal administration where they've only been deceased under the 2 years and the property is more than 75,000 or the corpus of the estate is less than 75,000, not counting the home. So the will can go either way. The will is used if there's no beneficiaries, meaning beneficiaries on bank accounts or whatever, and whatever needs to be probated, meaning it's only in my name. It's only in my name. So it can't go directly to anybody. It has to be probated. The will is presented to the court. So we attach it to our petitions, our petition for summary, our petition for formal. We attach the will and we file it. Now, everything's electronic these days. So we file it by e-file, e-portal on the computer. The court requires us to hand deliver the original will. They want to see that original will. They want to make sure we haven't cut and paste things, that there's an original will with original signatures on it. So we have to hand deliver that so the court can verify. Now, what if we can't find the original will? Then we got to do a petition for lost will. We got to bring the witnesses in. It's a big mess. So please keep your original will in a safe spot and let people know where it is so they don't have to do that. But that's kind of gets the ball rolling. The court looks at that will as your wishes. Your wishes. That's what the court wants to make sure happens. Your wishes, William. So let's say your cousin comes in and says, no, William didn't want that. William wanted this. The court's going to be like, okay, but we have this will and this is what it says. Oh, no, he didn't know what he was doing at the time. Now you have a whole nother ball game here where you got somebody fighting over whether or not that will is authentic, whether or not, William, you were coerced by your other cousin, Susie, and all that. And that's when those fights come up. In fact, in the state of Florida, here's a little tidbit for you. I learned there's a law called intentional interference with an inheritance. Who knew? I just had a friend that was served with one. Now I know everything there is to know about that. But what the court, that's a tort. That's a tort. That can actually be brought in front of a jury for a jury to decide if there was actual interference and who gets it. But in the state of Florida, you first have to exhaust all your remedies in probate court first before you jump the fence into that intentional intentional interference with an inheritance. So I have a friend going through it right now that I'm helping her with. But anyway, so that's the court looks at it and they want to make sure your wishes are taken care of, William. So that's really what they're going to look at. But William, you can have the ironclad will. You can have the best will possible. People still may fight. And that's just the nature of the beast. And that's why I'm telling you, try to do the best you can to make sure that stuff doesn't go into probate. Beneficiaries, whatever you can do, get rid of it while you're alive, spend it. Hey, go on the trip you always wanted to go on, but enjoy, try not to. I mean, probate is necessary and it's there for a reason. But if you can avoid that and avoid the cost and avoid the fight, sit down with an estate planning attorney. I go over everything with them. What are your accounts? What are this? What are that? To steer them down the best avenue. And I'm always trying to get them, let's try to avoid probate, just so your family can enjoy things right then and not have to worry about all that, when you pass away. Okay. Oh, I'm just trucking along here. Okay. So my last, but certainly not least, what I've been talking about this whole time, creditors' claims. Oh, those things are tough, let me tell you. What I see a lot of time, when I see creditor claims, we call them creditor caveats here in the state of Florida. A creditor can file in the court, and like I said, they can file even if a probate is not filed. They can file a creditor claim in the court and just have it sit there. Now, they can't come after the estate. They have to wait till a probate is filed. So if a probate's never filed, then the creditor just hangs out there. Just hangs out to maybe someday, somewhere, somehow, somebody might file a probate. So let's say a month after I die, my American Express card files a creditor claim. Okay, they're locked in. So if my husband files a probate, they're there and they're a valid creditor claim because they filed within the time frame. So a month after that, my husband files a probate. The creditor's claim is there. So because it's within the 2 years of my death, they have a valid creditor claim. So how do we ascertain who these creditors are? Now, we can't just do this. Nope, she didn't have any creditors. Yay, I get to, probate. I get everything. No. If they've been deceased less than 2 years, the personal representative has to do their due diligence, whatever that may be, to try to find any known or ascertainable creditors. So what do I have my clients do? Okay, grandma passed away. Do you know of any creditors? I don't know what grandma had. I have no idea what grandma had. Okay, well, go in the house, see what mail, go through paperwork, see if there's anything, like those people that buy a house and are starting to act like their parents and they print everything off the internet and put it in their little file cabinet. It's so cute. Look through things. Chances are there's bills hanging out somewhere. There's something there. Or something that later on comes in the mail that you can give to your attorney. So your attorney can send them a letter. And so the attorney will send that creditor. So you find, again, my American Express. Oh, look, here's a bill for American Express for $5,000. But it's dated 2021. I wonder if it's still valid. Well, just give it to the attorney anyway. The attorney, it's better to be safe than sorry, I always say. So the attorney can send off a creditor claim. What it is a notice to creditors, and it explains to that creditor, hey, you better file your claim within a certain amount of time. Otherwise, you're going to be forever barred. And the reason why we send it certified mail is because guess what? We have a little signature that it's been received by American Express. Now, I don't know who signs for those certified letters. I have no idea. I don't know if there's some receptionist in the front that signs up. I have no idea, but I don't care because it's signed by American Express, right? It's signed by somebody at American Express. So what I do is when I get that little green card back, remember they still have those green cards. I know it's hard to believe, but the little green card, I then file it with the court saying, okay, I sent to the known creditor, American Express. I sent it to them January 1st. They have a certain amount of days. If they don't file within that certain number of days, done. Unknown creditors. I have no idea. I found nothing. Grandma's house with a vault. There was absolutely no paperwork. There's no mail. I don't know what happened. There was a fire. Whatever happened, I don't know who the creditors are. So for any unknown creditors, I have to post in the newspaper. At least here in Florida, I have to post in a newspaper that's county-wide. So I live in Seminole County. So I got to find a newspaper that publishes Seminole County-wide. Not just like I live in the city of Apopka here in Seminole County, and I get the little Apopka Chief. Now that's just for the Apopka area. That's not Orange County. That's not Orange County wide. In Orange County, like there's the Orlando Sentinel, which that would be quite pricey. We use a little newspaper called the Jewish Heritage. They're a lot cheaper. And they're countywide. They're countywide. So we post the notice to creditors. Now take some time to look in your newspaper and see the little notice to creditors. That notice to creditor alerts any unknown creditors. So let's say I also had a discovery card, but you didn't know anything about it. Discovery, and this is crazy, right? Discovery has a job to, I guess, read the paper and say, oh, look, Laura Sterling, she's one of our card holders. She died. Let me file a creditor claim. Really? Do you think people do that? But anyway, that's the law here in Florida, that we post that notice to creditors, and then the creditors have a certain amount of time apparently to read that newspaper and to get their creditor claim in. If they don't do it within that time frame, they're forever barred. Hi, Luca. How are you? Hello, Attorney Sterling. Oh, I love your picture, by the way. I'd like to know, how does the presence of a surviving spouse or descendants affect intestate succession? Boy, you're good. You really know what to say. It depends on, like I said before, the relationship of the surviving spouse. If the surviving spouse and you share the same children, everything goes to the spouse. That is just in his name. I mean, if there's things that jointly owned with the children or whatever, that's different, you know. But if the surviving spouse doesn't share children with you, but you have children from another person, then that surviving spouse only gets a half, and the children get the other half. So, they're a little more to it than that. It would be another live, but that's kind of how it goes. If they don't share children, then that surviving spouse only gets half, because I guess the law looked at it as, well, we need to take care of the wife, but we also need to take care of these children over here, because now dad's died. And if everything went to stepmom, these stepchildren can't inherit from me because they're not my blood. They're my step. They're like, now that my spouse has passed away, I really have no connection to them, right? And so they don't stand to inherit from me. Now, if I do a will and I put them as beneficiaries, that's different. They can get that. But if I don't, if I die intestate without a will, it'll go to my heirs. If I have children, it'll go to my children. Or if I have no children, then it would go to my parents. If I don't have any parents, then it's going to go to my siblings. It just keeps going on and on. And so they don't stand to inherit. So the state of Florida, I guess, was like, hey, we need to protect this. You have so many blended families and everything. So they wanted to protect that. So very good question, Luca. And I do like your picture. It looks like you're a little handyman there, a little crafter. So that looks very nice. So good question. But anyway, so creditors. So these creditors, they can file a claim. Like now, I told you, I said, I had an estate that's been open forever. We did the known creditors. We sent off to known creditors. We actually have one creditor that we do need to satisfy. So we have one creditor, and then we have, we did the notice to known creditors, which were very few. And then we did the notice in the newspaper for unknown creditors. And the only one person filed a claim, one, I don't even remember. It's probably a pharmacy or something. I have no idea. They're usually pretty quick on things like that. But anyway, it was T-Mobile. I mean, really? T-Mobile filed a claim, and it's been open forever. All the creditors' claims are barred because we did everything we were supposed to do to known creditors and unknown creditors. And pop, out of nowhere, about to close, and out pops this creditor's claim. I'm like, oh, no. So I had to file a motion to set it aside, which of course the judge granted. So they don't get their little, I think it was like $300. I mean, really? So there's, and what sometimes happens as well, as well as I do, you call American Express, you're talking to 3,000 different people. I mean, American Express is huge, right? And again, like I said, I don't know who signs those. What do you want? The little certified mailings. I don't know who does it, but I don't know. They must not put it in the system because it never fails. I seem to have a creditor call long after the estate's closed, long after everything's been done. They call my client, and my client calls me frantic. And I said, "Oh no. We received the green card back from American Express. So give them to me. I will take care of it because you're barred. I'm sorry, you're barred. So I think they may be trying to, and I don't know the law about this, reviving the debt. That's not my forte. Um, but anyway, but it's barred. It's barred. So just keeping up with that creditor's claim. And what sometimes is helpful is keeping that stuff in order, making sure that everything, that you have stuff in order so people come into your house when you pass away and they know what to get. Let me tell you, I've gotten stacks of paperwork, stacks of paperwork. I don't know what all this is. And I don't know. And then they want me to go through it. And I have no idea what it is, what they own, what they owed. And sometimes I'm getting bills that are dated 1990 something. And I'm like, I don't, and they won't talk to my person until they're appointed personal representative. We like to kind of include everything in the petition, but sometimes it's just impossible to list creditors and assets. We just can't get how much are in accounts. Is that account still open? Because one, nobody will talk to us until a personal representative is appointed and they have that certified letter from the court. So anyway, so that's creditors' claims. Creditors can claim. There's a succession of how creditor claims get paid. Of course, off the top, of course, is any costs of the administration, attorney fees, filing fees, anything like that. Secondly, there would be medical bills. Are there any medical bills that need to be paid? Those medical bills have to be within 60 days of death. So you can't get some creditor claim from a medical bill from 2 years ago. No, it has to be within 60 days of the death. Um, and then there's going to be taxes and stuff that potentially could be owed. Depends, inheritance tax. I mean, you have to really be a millionaire to have that come into effect. They keep raising it, which is fine. And lastly is everybody else, credit cards. Usually you generally when I have credit cards and there's a lot owed on them, but there's very little left in the estate, I'll call the credit cards pro rata. They'll take a portion, okay, I'll take $10, depending on what's ever left over. And they send in a satisfaction of creditor claim, and then I can close the estate. So, those are creditor claims. Anyway, I hope I answered all your questions. You guys had excellent, excellent, excellent questions. You guys are getting smarter and smarter and smarter and smarter. You don't need me. You don't need me to do these lives. You guys seems to know what you're doing. But I'm glad that I can help, and I'm glad that I'm here for you. Please know that we're here. If you live in the state of Florida, please, please, please feel free to give our office a call. That's what I'm here for. I'm here to help you. I'm here to make things I'm here to kind of take that stress off your shoulders. Generally, when people come in, I had somebody come in, their mother had just passed away 5 days earlier. They were a wreck in my office. And I'm like, go home, take a breather, come back when you've grieved a little more. I'm here. I'm here all the time. So I'll be here for you, but take a little time to grieve and then come in and we can go over everything. So make sure if you have questions, if it's anything at all, give us a call. Make sure you check me out on Facebook, on Instagram, my podcast on Spotify, my blog. I'm everywhere. I'm just everywhere. I'm not on TikTok though. I am not a TikTok. I can't keep up with those young people on TikTok. I'm getting old. I need to stick with the old stuff. So I'm sticking with the tried and true. But I'm so glad that you can join me next month. Since we're sliding into spring break, I'm going to switch gears and talk about family law. I'm going to talk about parenting plans. So fun time. Stay tuned next month. And if you have any questions about probate, I'm here for you. Give us a call.